Good evening, everybody. Hello, happy Sunday. Happy Sunday evening. Welcome in. Good to see you all. I was on a little bit earlier this morning just to chat and say hello. So we're back again, back to work, back to business. So good to see you. Hello, Jen. Hello. Welcome. Welcome in. Oh, hello, Olga. Good to see you as well. Yes, we've got a very interesting order here. Hello, Trish, James, Rich. Good to see you. Thanks for coming. We've got our sub chat set for Sundays as per usual, everyone. So that makes just sets our chat so that it's our subscribers only, but everyone can come and hang out. Happy to do that. The Ergati indictment. Oh, I'm not sure if I have or not. I'll have to check let me write that down. I'll go in and double check and see. I do have a lot of paperwork that I always have to go through. So sometimes I forget what I have and what I don't have. So I will have to double check on that for sure. Hello, Kaya. Hello, welcome. Hello, Mary. Good to see you. Yeah. So I had pulled a whole bunch of different indictments. So I'll have to go through my indictment folder and double check and see who I've got in there. I've got love my nails. Oh, thanks everybody. I'm not sure about the nails tonight, everyone. I'm not sure. They're tortoise. They're not, I don't know. We'll see. We'll see how I feel about them. See how I feel about them at the end of the night. Yes, of course, Sarah. I've got it written down. So I'll take a look. I'll pull that indictment folder. Love the tortoise. Oh, thanks. Thanks so much. Signal sent out. Oh, Suze, you're just the best. You are just the best. That's so sweet of you. I appreciate it so much. I'm so thankful. And I did want to also say I just had so much fun, everybody. We had our special subscriber only hangout Friday night, and oh my gosh, that was so fun. Oh my gosh, we laughed, everyone. We laughed. We laughed so much. It was so much fun. Oh my goodness. So we will definitely have to do that again very soon. We'll have another fun Friday. Oh my goodness. Sometimes, everybody, you just have to laugh sometimes. Sometimes you just have to take a moment and gather your wits together and then lose them again. So, yes, it was quite the time. I appreciate everyone that came by. That was a lot of fun. So welcome to our Sub Chat Sunday. I've just got the chat turned to subscribers only, and this is just every Sunday. This is what I do. All of the rest of my chats I have set for everyone. I do occasionally, I've started to do subscriber only lives where we are just hanging out. Anytime I'm doing any kind of document or update or any kind of legal educational thing, I always have that open available to the entire public. But if we're just going to hang out and have a little fun, we had a bit of a movie night on Friday. So I do really enjoy doing that with my subscribers. So I was able to do that this past week. But if I've got something that is a document or something like that, of course, we'll have it turned on so everyone can watch. Subscribers only on Sunday, just for the troll prevention to give the moderators a break. So tonight, everyone, I have the dismissal order for Mr. Giuliani's bankruptcy. So who remembers what was going on with Mr. Giuliani? So Mr. Giuliani's been in some troubles. He's had some troubles. Oh my gosh. He was sued. The biggest one, of course, was the defamation case against there were two election workers in Georgia, and he said some clearly false information that got out that led to some horrible repercussions for these two women. So they sued for defamation and they won. Murder, She Wrote. Oh, we might be able to do that. That'd be fun too. Oh my gosh, that'd be very fun. So after he was found, he had already been found liable, but they did do a a damages portion, which means the jury needed to come back with damages. And after the damages were set out in this case, he had declared bankruptcy, claiming he didn't have the assets to cover what was going on. So bankruptcy is one of the ways that people can try to take care of creditors and so on. I'm not a bankruptcy expert by any means, everyone, but I think we all have a basic understanding of bankruptcy. He did file in New York, and then there were several twists and turns that occurred, and the judge finally came out and said, no, we're not going to let you file. So that's what this is. This is our order dismissing his bankruptcy case. So that's what I will be reading through tonight, and I think the judge did a pretty good job explaining it. Intent doesn't cover bankruptcy. Right. So, if you've got intentional torts, you are going to wind up having to pay that anyway. But what bankruptcy can do is get rid of any other kinds of debts that you may have to kind of clear the field to help you go down that road anyway. So even though there wouldn't have been a way to, through bankruptcy, get rid of his judgment here, it could have gotten rid of other things. So I think it will be a really interesting order to take a look at here. Oh my goodness, the toner, everybody. Well, now that the case is back in DC, I think we're gonna have to definitely take a look at the toner. I was shaking it this morning, the toner. Toner cartridges all get shaken properly, just to make sure we get every last drop out of the toner, everyone. Oh my goodness. Hello, Tay. Good to see you. So let me go ahead and get started, everyone. Reading of the judgment or the dismissal. So this is the order again. So just to remind everybody here, this is the Giuliani Bankruptcy Dismissal Order out of New York. Now up here is going to be the case number. This is the date that it was filed, when it was entered into as well. So let's go ahead and dive right in and see what the judge has to say here for Mr. Giuliani. So here we go. We have Judge Lane, a United States bankruptcy judge. Before the court are two motions, both of which would end Rudolph Giuliani's ability to run his Chapter 11 case as a debtor in possession, but in different ways. The first motion is the motion of the Official Committee of Unsecured Creditors, the committee, for the appointment of Chapter 11 trustee, the trustee motion. And then we have footnote number 1 here. Unless otherwise specified, references to the case management here are to case 23-12055. So anyone who's interested in that case number, it's here. The trustee motion was joined by creditors, in this case known as the Freeman plaintiffs, but it was opposed by Mr. Giuliani. So, and then we've got another footnote down here. Can he appeal this? That's a good question. Let's get to the end of it and see exactly what the judge has said, and then we'll kind of go through that process. The term Freeman plaintiffs refers to Ruby Freeman and Wandrea Moss, the plaintiffs in Freeman versus Giuliani, the defamation action brought against Mr. Giuliani in the United States District Court for the District of Columbia that resulted in a judgment of approximately $148 million, which was huge. That's huge. No matter who you speak to, that is a huge judgment against a defendant, or I guess it's civil court, so we don't have to call them a defendant, but I will. Here we go. So the trustee motion was filed late May of 2024 and argued before this court on June 17th of 2024. The second motion, which was filed only after the trustee motion was fully briefed and argued, is the debtor's one-page application to convert this Chapter 11 case to Chapter 7. The conversion motion was signed by Mr. Giuliani rather than his counsel and did not explain the basis for the proposed conversion. And judges frown on that. Both the Freeman plaintiffs and the committee opposed conversion. Objection of the committee also is set here, and then the Freeman and Moss are objecting here. While both the committee and Freeman plaintiffs objected to the conversion motion, their objections take different views on appropriate outcomes here. The committee continues to assert that appointment of a Chapter 11 trustee is in the best interest of creditors, while the Freeman plaintiffs argue that dismissal is more appropriate. The court held a hearing on the conversion motion on July 10th of 2024. Approximately an hour before the hearing on the conversion motion, Mr. Giuliani filed a notice of the debtor's consent to dismissal, together with a proposed form of order. That's interesting. An hour before. The consent notice indicates that Mr. Giuliani consents to the dismissal of the case, or in the alternative, seeks conversion to Chapter 7. The proposed form of order attached to the consent notice provides that the dismissal would be with prejudice, with Mr. Giuliani being prohibited from voluntarily filing for relief under any chapter of the Bankruptcy Code for a period of 1 year from the dismissal of this case. At the hearing, the court heard argument on the best course forward for the case given the shifting landscape. For the reasons that will be discussed, the court finds that dismissal of this bankruptcy case with 1 year bar refiling is in the best interest of the creditors. So he cannot refile for 1 year. So that is kind of like, I don't know, we wouldn't call that necessarily with prejudice. I guess with prejudice with a time limit is I guess what we would call that. Here's our background. Mr. Giuliani filed a voluntary petition under Chapter 11 of the Bankruptcy Code in late December of 2023. Mr. Giuliani has operated as a debtor in possession since the filing of this petition. Mr. Giuliani explained that the bankruptcy filing was precipitated by the entry of a judgment against Mr. Giuliani in the Freeman litigation. The Freeman litigation involved a claim brought by two individuals who had worked as election workers in Georgia during the 2020 federal election. The Freeman complaint alleges that Mr. Giuliani defamed the Freeman plaintiffs by falsely alleging that they committed election fraud. The Freeman complaint further asserts that Mr. Giuliani made these statements over a period of more than 18 months, despite knowing that the statements were false, resulting in significant harm to the Freeman plaintiffs, including loss of employment, threats to their physical safety, and ongoing emotional and physical distress. Approximately a year and a half after the commencement of the Freeman litigation, the district court issued an opinion entering a default judgment against Mr. Giuliani. And that is one of the kickers about this defamation case, everybody, is that it's a default case. There was no, he put no defense on. It was just defaulted. Between Chapter 11 and Chapter 7, I do not know. Straight up, I do not know the difference between those two chapters in the bankruptcy code, or bankruptcy versus something else. I just don't. I apologize for that. In a case as a discovery sanction, so because he did not comply with discovery, that's why he defaulted on the judgment. Finding that Mr. Giuliani refused to comply with his discovery obligations that thwarted plaintiffs Ruby Freeman and Ms. Moss's procedural rights to obtain any meaningful discovery in this case. What does a default judgment mean? So default judgment means that no case is being put on. The judge is just ruling for the plaintiffs. So the judge would go into court, sit down, and say, I am holding for the plaintiffs without any trial here, without any evidence, without any of that. And he did it because Mr. Giuliani was messing around so much with the discovery in the case that the plaintiffs weren't able to get any discovery that they requested for a very long period of time. And so the judge defaulted on it as a punishment for that discovery issue. The district court detailed the ways in which Mr. Giuliani had his related entities and his related entities had failed to comply with his discovery obligations. So it's a pretty harsh sanction, but if his discovery was that out of line, then it's appropriate. In deciding to impose the most severe discovery sanction, the district court found that Mr. Giuliani had made crystal clear his choice: total debt forgiveness versus debt reorganization. Oh, thank you very much. I appreciate that. I did not know that. His choice not to comply with his discovery obligations. With the imposition of the default judgment, Mr. Giuliani was found to be civilly liable for the Freeman's plaintiff's claims of defamation, intentional infliction of emotional distress, civil conspiracy, and punitive damages. And of course, the punitive damages are what made the damages so high. The Freeman litigation then proceeded to trial for a determination of damages. After trial, the jury awarded plaintiffs sum of $148 million in damages, which included $75 million in punitive damages. Again, everybody, I cannot overstate how unusual it is to have a punitive damages award of $75 million. In the legal field, this is, it's just absolutely, it's so incredibly rare. This is a unicorn, so to speak, because this level of damages is not normal in most cases. Shortly after, a judgment was entered against Mr. Giuliani, declaring, among other things, that Mr. Giuliani engaged in extreme and outrageous conduct, which intentionally and maliciously caused the Freeman plaintiffs to suffer severe emotional distress. Less than a week later, Mr. Giuliani filed this bankruptcy case. Approximately 3 weeks after the case was commenced, the committee was appointed. Shortly after the commencement of the bankruptcy case, Mr. Giuliani filed a number of motions focused on the Freeman litigation, including a motion to lift the stay to permit Mr. Giuliani to file post-trial motions and a notice of appeal of the judgment in the Freeman litigation. And then we're citing how that occurred here. So, though the committee and the Freeman's plaintiffs initially opposed the motion to lift the stay, the parties ultimately agreed to a consensual order lifting the stay for the limited purpose of allowing Mr. Giuliani to file post-trial motions with the district courts and a notice of appeal. So again, we're just kind of going through the procedural history here. After the district court denied Mr. Giuliani's post-trial motion, Mr. Giuliani then filed a second motion seeking to lift the automatic stay to allow him to proceed with the appeal of the Freeman litigation, as well as a retention application seeking to retain new counsel for the Freeman litigation. Here, and they're citing that, citing more of that. This second lift to stay motion was filed about 4 months after the bankruptcy case was filed. The committee and the Freeman plaintiffs objected to both the second lift stay motion as well as the retention application. The court denied the second lift stay motion, giving the lack of progress in the bankruptcy case and concern that the appeal would distract Mr. Giuliani from reorganizing and will serve as an excuse for further delay in taking critical steps. Here, and again, I'm skipping the titles of the orders and different motions here. That is what I'm kind of skipping through here. While Mr. Giuliani's attention was directed at the Freeman litigation, the committee pursued information about Mr. Giuliani's financial situation. Large penalty to set an example for anyone threatening election workers. Absolutely, that's absolutely right. And that's what punitive damages are. They are meant to punish the wrongdoer. That would be needed for the bankruptcy to move forward. In March of 2024, for example, the committee filed a motion pursuant to a federal rule of bankruptcy procedure 2004 for authorization to seek discovery from Mr. Giuliani and other third parties, including business entities wholly owned by Mr. Giuliani. And then we've got the motion there. Mr. Giuliani did not object to the motion, and the court granted the motion in early of April of 2024. Pursuant to the rule, the 2004 order, the committee began serving subpoenas on a number of different parties and sought an examination of Mr. Giuliani. The parties from whom the committee sought discovery, including Mr. Giuliani's wholly owned businesses, these entities include, so here are his businesses listed: Giuliani Partners, LLC, Giuliani Group, LLC, Giuliani and Company, LLC, Giuliani Security and Safety, LLC, World Capital Payroll Corporation, Giuliani Communications. So these are his businesses, everyone. Let's just take a minute and highlight these out. So we've got partners, a group, company, a security group, payroll corporation, and communication. Oh, goodness. And then they're citing where they got that information from. Mr. Giuliani owns 100% of each of these entities. The committee also sought to compel Mr. Giuliani to sell the condominium that he owns in Florida. And then they're citing the motion here. I'm skipping forward. In that motion, the committee argued that maintaining the condominium in Florida is a drain on estate resources and that the debtor appears to have no interest in monetizing this asset, contrary to his fiduciary duty to maximize the value of the estate for the benefits of his creditors. The committee made clear that the Florida condo motion was filed as an intermediary step to give the debtor an opportunity to discharge his duties to creditors and act as a fiduciary before the committee is required to take additional steps to protect the remaining value of the debtor's estate, including filing a motion to appoint a Chapter 11 trustee. And then skipping through the name of the motions. At the hearing on the Florida condo motion, the court perceived it as a shot across the bow at the debtor by the committee and a preview for more aggressive steps that the committee might take to move the case forward. Noting that more extreme steps may include opposing an extension for Mr. Giuliani's exclusive right to file a plan or filing a motion to appoint a trustee. In late April of 2024, the committee targeted the debtor's failure to comply with his financial disclosure obligations in bankruptcy. In the MOR motion, the committee noted that neither the monthly operating report for February of 2024 nor March of 2024 had been filed, and that even the monthly operating reports that had been filed contained only limited supporting documentation, with that documentation revealing more gaps in disclosure. At the hearing on the MOR motion, the committee did note that while the missing monthly operating reports had been filed, there were still deficiencies. So Giuliani really has some trouble here, everyone, with his documents and his discovery issues here. And he has counsel, so it's not like he doesn't have someone telling him what he needs to turn in here. In late May of 2024, the committee filed the trustee motion seeking the appointment of a Chapter 11 trustee under Section 1104C of the Bankruptcy Code. The trustee motion highlighted numerous significant and undisputed deficiencies in the debtor's financial disclosures. Oops. Disclosure obligations ranging from failure to comply with Rule 2004 discovery demands and incomplete and inaccurate schedules of assets and liabilities. After the trustee motion was fully briefed, the court heard oral argument and took the matter under advisement. Approximately 2 weeks after the hearing on one of the trustee motions, Mr. Giuliani filed the conversion motion. Here's our discussion coming up. So, Section 2, subsection A, the right to convert from Chapter 11 to Chapter 7. All right, so let's get into it. As a threshold matter, the court considers whether Mr. Giuliani has an absolute right to convert his case from one under Chapter 11 of the Bankruptcy Code to a liquidation case under Chapter 7 of the Bankruptcy Code. The conversion motion does not discuss whether the case should be converted as a matter of right. In fact, it says very little about the legal justification for conversion, but as a status conference on the conversion motion, Mr. Giuliani's counsel intimated that Mr. Giuliani could convert his case as a matter of right. Consistent with prior decisions in this district, however, the court finds that a debtor does not have the absolute right to convert a case from a Chapter 11 to a Chapter 7. In reaching this conclusion, the Adler Court noted that the statutory language providing for conversion is permissive, not mandatory, stating that a debtor may convert his case. The Adler Court went on to note that bankruptcy rules require that a motion convert from Chapter 11 to Chapter 7 must be made 20 days before, made on 20 days notice to creditors, rather than simply by filing a notice of conversion. Such notice would be required unless parties had a chance to object, and a court was required to rule on the request. In reaching this conclusion, the Adler Court noted that other courts found that debtors could be prevented from converting their case due to existence of extreme circumstances constituting bad faith, which I think we've definitely got some hints of bad faith going on in this entire situation. Outside of this district have similarly concluded that debtors do not possess an absolute right to convert their cases from Chapter 11 to Chapter 7. And we're citing case law. Indeed, Mr. Giuliani has not cited to any decision holding that a debtor's right to convert is absolute. This court's conclusion is also supported by the Supreme Court's decision in Marana versus Citizens Bank of Massachusetts. In Marama, the Supreme Court held the debtor does not have an absolute right to convert the case from Chapter 7 to Chapter 13. Notably, the Supreme Court in Marama was construing statutory language in Section 706D of the Bankruptcy Code that is essentially identical to the applicable language here in Section 1112F. Although we all pause when we hear the Supreme Court and precedent, but moving on. The 1112B standard also, so we'll hit on that. Having determined that Mr. Giuliani does not have an absolute right to convert, the court must determine the appropriate path here given the competing requests for relief. In assessing that question, the court turns to Section 1112B, which sets out the relevant standard. That section provides in relevant part, on request of a party in interest and after notice and hearing, the court shall convert a case under this chapter to a case under Chapter 7 or dismiss a case under this chapter, whichever is in the best interest of the creditors and the estate for cause unless the court determines that the appointment under Section 1104A of a trustee or an examiner is in the best interest of creditors and the estate. Taking our cue from statute, the court turns first to whether cause exists under the statute. So again, this is their analysis again on trying to figure out which way they're going to take this, these two motions that have been filed. So number one, cause. Section 1112B4 provides a list of 16 items that constitute cause. These include gross mismanagement of the estate, substantial or continuing loss to or diminution of the estate, and the absence of reasonable likelihood of rehabilitation, failure to comply with an order of the court, and unexcused failure to satisfy timely any filing or reporting requirements established by the Bankruptcy Code or by any rule applicable to a case under Chapter 11. This list contained in the subsection is not exhaustive. However, the courts are free to consider other factors. And then citing different case law, explaining that out. Tea break, thank you, Kaya. Yeah, I tell you what, everybody, my voice has just been a little bit rough recently. All right, there we are. The court finds that cause exists to convert or dismiss the case. So we've got our first piece here. The record in this case reflects Mr. Giuliani's continued failure to meet his reporting obligations and provide financial transparency required for debtor in possession. These failures are set forth in extensive detail in the trustee motion and the objection to the conversion motion. For purposes of brevity, the court will only highlight a few here. First, so this is where Giuliani has screwed his case up here, everybody. First, Mr. Giuliani has failed to respond to the Rule 2004 order. Most significantly, none of Mr. Giuliani's business entities have made any production at all, despite being required to do so by Rule 2004 order. The Rule 2004 order clearly allows the committee to serve discovery demands on Mr. Giuliani, as well as affiliated corporate. Boy, these guys really don't like to give their documents over. I'm noticing a trend. I'm noticing the trend here of that. Corporate entities, including Giuliani Partners and Giuliani Communications. The committee propounded discovery on those entities and Mr. Giuliani. And then they're citing the different filings here. However, Mr. Giuliani has only made one production in response to the Rule 2004 order, containing 15 documents consisting of Mr. Giuliani's bank statements, credit card statements, and income tax returns for 2021 and 2022. Changes to SCOTUS. Yes, we've talked about it a few times, Annette, but catch me at the end. We can chat about it again. So we're citing the trustee motion here, and then the different motions. So moving on, Mr. Giuliani's businesses have made no production whatsoever, nor has Mr. Giuliani or his entities identified any legitimate reason why the requested information should not or cannot be produced. This failure to provide even basic disclosure about these assets is sufficient in and of itself for finding cause. So he's just refusing to give over any of his information. Oh, you bet, Annette. Second, Mr. Giuliani has not fully met his obligation to file certain schedules and lists detailing his financial condition, including the list of creditors, a schedule of assets and liabilities, a statement of current income and current expenditures, and a statement of financial affairs. These documents are to be filed at or near the start of a case. The accuracy of these documents is vital to a bankruptcy proceeding because They preside a recent financial history of the debtor, as well as a list of his assets, liabilities, and contractual obligations. These forms are the debtor's representations of its own financial condition at the start of the case. They are signed under penalty of perjury. So remember that when you're signing your financial statements, everyone. They are critically important and must be accurate, since the information will be relied upon by all parties and form the basis for discussions regarding a plan. Oh, goodness. Oh, Mr. Giuliani. So, in early of March of 2024, Mr. Giuliani signed a stipulation acknowledging that despite previous amendments to his schedules of assets and liabilities, the Statement of Financial Affairs, further amendments and disclosures are necessary. However, since the execution of that stipulation, no amended schedules or statements have been filed, and the promised information remains outstanding. So he has not delivered on any of that. Yeah, the very basic, very simple basic rules here. Nothing too complicated. Moreover, there are deficiencies in the information that Mr. Giuliani has provided. For example, while Mr. Giuliani's initial schedules list no executory contracts, Mr. Giuliani in fact has a contract for an upcoming book. This information was only belatedly included in the schedules in February of 2024. Ooh, that's not good. You need to share that. Shortly before the trustee motion was filed, the committee learned through media reports that Mr. Giuliani was promoting a coffee brand. Oh, here's the coffee, everybody. He's in trouble. A fact about which Mr. Giuliani's counsel was purportedly unaware. Oh no. Oh my goodness gracious. You can't do that, people. You can't go. You can't do that. That's it's not a good choice. It's not a good choice. Third, Mr. Giuliani failed to fulfill his obligations to file accurate, complete monthly operating reports. A debtor in possession is obligated to file monthly operating reports that include information about the case and certain financial transactions and keep a record of receipts and the disposition of money and property received. As part of a debtor's continuing obligations during a case, monthly operating reports are required to be filed by the 21st day of the month, immediately following the reporting period covered by the monthly operating report. Every single monthly operating report filed by Mr. Giuliani was untimely. Oh dear. For example, his monthly operating, yeah, they don't like that either. I mean, if you're late once in a while, that's one thing, but if you're late every single month, yikes. So the report for February of 2024 was not filed until May 2nd of 2024, approximately 6 weeks late. In fact, Mr. Giuliani would often promise to file monthly operating reports by a certain date, only to miss those deadlines. Perhaps even more troubling, the information in the monthly operating reports has been incomplete or inaccurate. For example, the monthly operating report for February of 2024 attaches bank statements for the wrong year, February of 2023. This monthly operating report has not been amended or supplemented. Despite listing 3 bank accounts on his amended Schedule AB, the December 2023 monthly operating report only attaches a statement from one bank, and the monthly operating report for May of 2024 attaches a bank account statement for an account with an account number ending in 8958. However, no further information regarding this bank account had previously been provided in any of the prior monthly operating reports. The monthly operating reports also appear to contain errors, as none of the end-of-month cash balances match the opening cash balance for the following month. That's not good either. They frown on that as well. The lack of financial transparency is particularly troubling, given concerns that Mr. Giuliani has engaged in self-dealing and that he has potential conflicts of interest that would hamper the administration of his bankruptcy case. The income that Mr. Giuliani earns for his individual labors is funneled to his corporate entities. Mr. Giuliani's choice to route income into his businesses is concerning, given that his monthly operating reports reflect that Mr. Giuliani receives no income from these corporate entities. Oh, that's a red flag. Indeed, he purportedly received no income other than his Social Security benefits, even though he receives compensation of at least $15,000 per month for hosting a radio show on WABC. Oh my gosh, what? And between $100,000 and $150,000 for his work hosting a podcast called America's Mayor Live. Moreover, Mr. Giuliani's own disclosures demonstrate that he uses personal funds to pay expenses associated with his businesses without court approval. Yeah, that's pretty bad, everybody. And that's a lot of money. So that's $100,000 to $150,000. And he's saying he's just getting Social Security. Yikes. All right, Mr. Giuliani argues that operating through an alter ego limited liability company is customary and not nefarious. I love that, how they say everybody does it. But it is impossible to determine the appropriateness of these financial arrangements when Mr. Giuliani has completely failed to provide information about them. While Mr. Giuliani asserts that the revenue from his business was insufficient to cover expenses, thus purportedly explaining his lack of income from his work, he has not produced any documentation to substantiate that claim, a point repeatedly emphasized by the committee. In fact, the committee contends that the business entities have expenses that are significantly less than the income deposited into those entities. In the end, the only information we have are statements from Mr. Giuliani's counsel that counsel had been advised that the income deposited with the business entity did not exceed expenses and that the situation may change due to a new contract, but he was not in a position to say. This lack of transparency, apparently even in Mr. Giuliani's own counsel, raises significant concerns about Mr. Giuliani's ability and willingness to manage the bankruptcy estate in the best interests of his creditors. Mr. Giuliani does not contest the fact that he has not complied with his disclosure obligations. In fact, Mr. Giuliani concedes that his compliance with the operating guidelines was not up to par. That's okay. Though he is striving to adhere to the guidelines. Mr. Giuliani states that his difficulty with the financial reporting is due to the fact that his longtime personal accountant has declined to assist with the preparation of reports, and he cannot find another professional to become involved in the case. Mr. Giuliani argues that inaccurate record keeping is not the fundamental equivalent of fraud, and therefore Mr. Giuliani's reporting failures do not constitute cause for appointment of a trustee. But the court's not convinced. Notably, in the 3 weeks between the time the committee filed the trustee motion and when the court heard argument on the trustee motion, Mr. Giuliani did not provide any additional financial disclosures or take any steps to correct reporting that the committee has identified as inaccurate, nor has he taken any since. I'm wondering about that, though. Do you think it's difficult for him to find an accountant? I'm not sure. I have no idea. I really have no idea. I would imagine it would be a bit difficult, but yikes. In fact, Mr. Giuliani's counsel conceded that there are not yet records regarding how money flows between Mr. Giuliani and his wholly owned corporate entities. Mr. Giuliani's counsel also stated that Mr. Giuliani has not been able to retain any bookkeeper or accountant to work on his behalf. In the court's experience, such a fact is highly unusual and troubling, given that bankruptcy case has been pending for more than 6 months. When confronted with complaints about failure to satisfy the bankruptcy code's obligations as to financial transparency, most debtors will respond by curing at least some, if not all, of the defects. By contrast, Mr. Giuliani has done nothing. Number 2, best interest of creditors and the estate. Having found that cause exists, the decision as to whether to dismiss, convert, or appoint a Chapter 11 trustee is within the discretion of the court. Okay, and then we're citing case law here, explaining that discretion. Let me just make sure. I think I'm off. Hold on, everybody. Let me get squared up here. There we go. As a threshold matter, the court finds that Mr. Giuliani's case should not be converted to a Chapter 7 liquidation proceeding. Interestingly, his request to convert the case to Chapter 7 is completely inconsistent with his recent prior statements about the case. Just 2 weeks prior to filing the conversion motion, Mr. Giuliani filed a motion seeking to extend his exclusive time to file a Chapter 11 plan of reorganization, arguing that the exclusive period should be extended because Mr. Giuliani's bankruptcy case is complex. There exists unresolved contingencies which may have had a substantial effect on the plan. and Mr. Giuliani is proceeding in good faith towards resolving those issues. In any event, conversion to a Chapter 7 is not in the best interest of creditors, which again is the key phrase in any bankruptcy case, everyone. What is in the best interest of the creditors? Conversion is vigorously opposed by the committee and by the Freeman plaintiffs, both of whom correctly view it as a substantial step backwards. A newly appointed Chapter 7 trustee would need to learn the bankruptcy case from scratch without the assistance of the committee. That would be disbanded in any Chapter 7. Moreover, a Chapter 7 liquidation proceeding is ill-equipped to maximize any value from Mr. Giuliani's ongoing business ventures. Having determined that conversion to Chapter 7 case is not appropriate, the court turns to the remaining two options, dismissal or appointment of a Chapter 11 trustee. So those are the two choices available here for Mr. Giuliani. While the committee argues strongly for the appointment of a Chapter 11 trustee, the Freeman plaintiffs argue that dismissal is in the best interest of creditors and the estate. When considering whether dismissal or appointment of a Chapter 11 trustee is in the best interest of creditors and the estate, the court can look at a number of factors, including, and we're almost done, by the way, everyone, just so you know, we're coming down the finish line here. Number one, whether some creditors received preferential payments and whether equality of distribution would be better served by conversion rather than dismissal. Two, whether there would be a loss of rights granted in the case if it were dismissed rather than converted. Three, whether the debtor would simply file a further case upon dismissal. Four, the ability of the trustee in a Chapter 7 case to reach assets for the benefit of creditors. 5, in assessing interest of the estate, whether conversion or dismissal of the estate would maximize the estate's value as an economic enterprise. 6, whether any remaining issues would be better resolved outside bankruptcy. 7, whether the estate consists of a single asset. And 8, whether the debtor has engaged in misconduct and whether creditors are in need of a Chapter 7 case to protect their interests. They flaunt. Yeah, I feel like it's just a lot of talk. Like he just doesn't have the records to back up what he says publicly. But while these factors provide guidance, the court examines all of the facts of the case and to assess the best interests of creditors. Those facts support dismissal for many reasons. So that's where the court's at here. First, there is legitimate concern that remaining in Chapter 11 would result in administrative expenses that would erode much, if not all, of the value of the estate. In reaching this conclusion, the court is mindful of what's past is prologue. Said another way, there is little reason to conclude that Mr. Giuliani's uncooperative conduct will change after the appointment of a Chapter 11 trustee. Mr. Giuliani has failed to provide an accurate and complete picture of his financial affairs in the 6 months that the case has been pending. Transparency into Mr. Giuliani's finances has proven to be an elusive goal, despite the continued diligence and extensive efforts of the committee and the Freeman plaintiffs. The court sees no evidence that this will change going forward with a Chapter 11 trustee. The debtor has not even retained an accountant. That's like really a big deal, which is the most rudimentary of steps. I agree with the judge. I agree here. That's a big deal. Such a failure is a clear red flag, as has been previously noted by the courts months ago. The continued lack of financial transparency would severely hamper the administration of this case by a Chapter 11 trustee, who would be required to incur extensive expense to seek compliance from this recalcitrant debtor. Counsel to the committee argues that it is appearing pro bono. Oh, no, I didn't know that. Counsel to the committee argues that it is appearing pro bono and thus expense should be less of a concern. Interesting. But there's no expectation, nor should there be, that a Chapter 11 trustee would do so. And the court cannot appoint a Chapter 11 trustee without then supporting the trustee's efforts with appropriate resources such as accountants and financial advisors as necessary. This is exactly what the committee has done, retaining a financial advisor that has billed approximately $400,000 to date for its work. $400,000. Oh my gosh, everybody. Second, and relatedly, the stay in a Chapter 11 with a Chapter 11 trustee would be lengthy. In addition to unraveling Mr. Giuliani's financial circumstances, a Chapter 11 trustee would need to pursue the investigations already identified by the committee against the Republican National Committee and Donald Trump, both of which promise to be complex matters with uncertain outcomes. I'm sorry, what was that again? Let's back that truck up again. The stay in a Chapter 11 with a Chapter 11 trustee would be lengthy. In addition to unraveling Mr. Giuliani's financial circumstances, the trustee would need to pursue the investigations already identified by the committee against the Republican National Committee and Donald Trump. Wow. So that's interesting. Okay. Yikes. Both of which promise to be complex. All right, then. Moreover, a Chapter 11 trustee would not be able to make any distributions to creditors until liquidating the claims of the rest of the creditors other than the Freeman plaintiffs. Mr. Giuliani's schedules reflect at least 9 outstanding lawsuits. Oh my gosh, did we know that? Did we know he was involved in 9 other lawsuits? I didn't know that. I thought there were maybe a couple. I was unaware of 9, including the Freeman litigation. Other than the Freeman litigation, none of the lawsuits have been reduced to judgment. The plaintiffs in many of these matters have a right to a jury trial, making these cases better resolved outside bankruptcy forum. As those parties receive their day in court, to which they are entitled, this Chapter 11 case would remain pending with all creditors left waiting. Oh, from his former assistant. That's right. I get it mixed up because there's so many. Oh, that's right. I totally forgot VC. All right. Third, an extended stay in bankruptcy may be a value destructive in another way. In the case to date, the Freeman plaintiffs have stated their intent to assert administrative claims based on Mr. Giuliani's conduct. So let me just make sure I'm not too crooked here, everybody. I know that drives some people absolutely bonkers. And when I come back through and watch these lives before I post them later, it drives me bonkers also. I'm like yelling at myself, like, straighten the paper. Oh, all right. In repeating the same defamatory statements against Freeman plaintiffs that they were subject of the defamation case in the district court. So he's still saying some of the things that he's already been held liable for, is what they're saying here. Wow. So counsel to the Freeman plaintiffs are stating that Mr. Giuliani's post-petition conduct has given rise to administrative expensive claims. Complaints seeking to enjoin Mr. Giuliani from continuing to make defamatory statements against the Freeman plaintiffs. Wow, when he's got a judgment against him this huge and he's still talking about it, it's like, wow. Such statements expose the estate to liability that severely threatens the recovery of any unsecured creditors who can only recover after the Freeman plaintiffs would receive payment on any such allowed administrative claim. There is a serious risk of such continued conduct by Mr. Giuliani, with the attendant administrative expense and given the history in this case and the Freeman litigation in the district court. So the judge is worried that he could get sued again from at the same road, down the defamation road again. Counsel for the Freeman plaintiffs noted that on June 3rd of 2024, after the injunction prohibiting new defamatory statements against the Freeman plaintiffs was issued, Mr. Giuliani published a statement on the X platform that allegedly violated the injunction. What? When this risk is considered together with the cost of administration going forward, there's a real prospect of unsecured creditors receiving little to nothing in bankruptcy, notwithstanding a lengthy delay during which they are prevented from pursuing their rights. So he's got a violation of an injunction in place. Oh my gosh. Wow. That's a lot, everybody. Mr. Giuliani needs to talk to somebody. Fourth, there's also a credible risk acknowledged by Mr. Giuliani's counsel during argument that Mr. Giuliani would decide to cease any income-producing activity if a Chapter 11 trustee were appointed. So he quit working? Oh my goodness. The threat of such outcome supports dismissal under factors 4. Oh, wow. And 5, under such circumstances, the only viable plan of reorganization would be a liquidating plan with limited asset pool that would be eroded by administrative expenses. 5th, Mr. Giuliani has agreed to a 1-year filing bar following the dismissal of this case, alleviating concerns that Mr. Giuliani would simply file another bankruptcy as soon as this case is dismissed. The year-long bar will provide time for creditors to pursue any rights, including executing on existing judgments or pursuing unresolved litigation. Accordingly, Factor 3 favors dismissal. Other factors also favor dismissal. As the Freeman plaintiffs noted, there's no evidence of any creditors receiving preferential payments whose recovery could only be pursued in bankruptcy court. Nor is there a need for the appointment of a trustee to protect the interests of creditors, given that the Freeman plaintiffs and other litigation claimants have able counsel representing their interest. A consideration under Factor 8. Finally, the Freeman plaintiffs argue that courts evaluate the preference of creditors when determining the disposition of a case, and that the view of the Freeman plaintiffs should be given substantial deference as the largest unsecured creditors with a fully liquidated judgment. Yeah, like that's like $148 million. Yikes. On the other hand, the committee is legitimately concerned that dismissal would effectively create a race to the courthouse for unsecured creditors with unliquidated claims who would otherwise be treated equally during a bankruptcy with the Freeman plaintiffs, who already possess a judgment. Given that any distribution to unsecured creditors is very far from certain, however, the court finds the committee's concern is outweighed by the benefits to the creditors from dismissal. Forcing creditors to wait years while they are prevented from pursuing their rights for, at best, a modest distribution seems inequitable and ill-advised. Considering the totality of the circumstances, weighing in all the factors, therefore, the interests of the creditors and the estate are better served by dismissal. Conclusion: for the reasons set forth above, the case is dismissed. Counsel to the Freeman plaintiffs should settle an order on 3 days' notice. The proposed order should be submitted by filing a notice of the proposed order in the case management electronic case filing docket with a copy of the proposed order attached as an exhibit to the notice. A copy of the notice and proposed order shall be served upon Mr. Giuliani's counsel, the committee, and the office of the United States Trustee. And then we are signed by our judge here. We do have a footnote number 5. And it says, the parties disagree on whether the fees of the committee's financial advisors must be paid as part of the dismissal. As a no-fee application is before the court, it's premature for the court to determine what fees should be paid as part of the dismissal. I love that. All parties reserve their rights on this issue, which can be addressed after the proposed order, and any responses are filed on the docket. So the committee's like, we want to get paid. And the judge is like, I don't think anybody's going to be getting paid in this case. Wow, everybody. Okay, so that is the dismissal for Mr. Giuliani. So what are our thoughts here? This is, wow. You know, he has multiple criminal cases going, as we know, and he does have civil cases going as well. If he passes, what happens? So what happens would be his estate would be divvied up, and it's all about order of importance when it comes to creditors. So the biggest thing he wouldn't be able to make any more money. His estate could make some money, but the income that would be coming in would change if he were to pass. Mm-hmm. Yes, they are a little bit spicy tonight, aren't they, Kristen? Is blowing up. Oh, I know. How sad is this, everybody? I mean, he went through, and if you remember, like, what he was doing on January 6th, if you remember his role in that situation, and you remember how involved he was with everything that was involved with, going to the different state houses to say that there was evidence of fraud. I mean, and there wasn't. And it's just, he was like, that was his peak. Like, he peaked there. And because of all of that fraudulent behavior. Like, he is just like downward spiral on that. Yeah, he destroyed himself. I think that's accurate. I really do. And it, I hate to see it. I hate to see it, everybody. I absolutely hate to see it. But I also hated to see him destroying these women's lives in the defamation suit and the criminal actions that he's been charged with. Not found guilty beyond a reasonable doubt, only a charge by a grand jury. Let's just be clear about that, okay? But it's a lot. It's a lot, and he's definitely paying for it. But I wonder too, though, do you think I really don't know. Do you think he really understands what's going on? I mean, if he's filing stuff in this case like an hour before a hearing, it's like he realizes that he needs to do something here. He does understand, what's going on, but his law license has been revoked. He can no longer practice. I have no empathy for him at all. I think it's hard to find empathy for the villains when things go bad for them. I think that is difficult to do. I cannot help but feel bad for any human going through this kind of situation. But of course, that weighs against the people who have been harmed by Mr. Giuliani. So I think we have to balance that out. Like, this is awful. This is a terrible situation, but let's balance that with everyone that he hurt in order to create the situation. Determined to be mentally incompetent at some point. Yeah, then he would have to have his, he would have to have power of attorney. Whoever's going to take care of things when that happens would need to come in and grab it. Can we talk about the RNC and Trump thing? Yeah, everybody, what's that about? So it looks like the committee that's been overseeing this and going through are saying that there are some significant investigations that need to occur between the RNC and Donald Trump regarding Mr. Giuliani. And there had been some whispers about this before, that Mr. Giuliani had some assets that he was being owed. And so it looks like what they're saying here is the committee is saying that this needs to be investigated. That's what I got from that. I mean, I've not seen any official reports, but is that how everyone else kind of took that statement? That the committee is saying we need to have an investigation regarding that? I'm sorry, everyone, I'm taking a tea break here. Yeah, that's what I got too. Yeah, and we don't have that information available to us yet. And the judge here is saying it's going to be a very complicated kind of situation, and I don't doubt it. I mean, how would you even go about trying to get the records from RNC and Trump? I mean, man, they just hold on to those records so tight. They found a link and they wanted to follow a line. That's that's what I'm thinking too. I'm thinking puzzle piece, everybody. Hold on just one moment, please. One moment. There we go. Oh, I got it. That's what I'm thinking too, is that they found something and they need to take it further to figure out what all's involved in it. He could have gone down as the best mayor of New York. Yeah, that's another thing too. I wonder to myself, like, is it a power thing, or is it like a friend in need is a friend indeed? I'm wondering which route was more important to Mr. Giuliani. Was it this idea of this huge amount of power, or was it, this is my friend, my longtime friend, let's all go down together? I'm not sure. I'm not sure which is more important to him at this point. Because that's power. You think it was power? You think it was a power? Has he paid anything yet? No. That's what they're working on right here. And the ladies here, they've got some good attorneys. They're not playing around. Like the RNC was paying Giuliani's legal bills. Now that I don't know, but there's definitely somehow involved. They're somehow involved in that, and it needs to be looked at further. It seems like he was just trying to stay relevant. Oh, that's a good point too, Trish. Was he that's a tough moment when you fall out, when you are in the spotlight, such a huge spotlight, that a spotlight like that, and I think about that on the big speech on January 6th with the people that were giving their big speech, and the crowd in front of them, and everyone's like rah rah rah, and they're like, whatever, and you step down from that, and you think about that kind of accolades and how difficult it is to recreate that. And so you just kind of try to get the next, bigger crowd or the next bigger thing in order to recreate that. And I think it's really difficult. Yeah, you have to acknowledge some things are just once in a moment situations. Sometimes, people may absolutely adore you in a moment, but you got to walk away from it. If you keep trying to recreate it, you're going to get into trouble. Adrenaline rush. I agree. Thought Trump would put him into a powerful position. Yeah, I think so too. And I thought there was some discussion about, there's a whole bunch of presidential pardon issues out there as well, which makes a lot of sense. And that's the other thing is that, to kind of think about if Mr. Trump does, get elected, one of the things to think about is, well, he'll pardon himself. Well, maybe. But the thing is, all of the dozens and dozens of other people involved, he could give pardons to. So all of them could be, taken. Yeah, exactly. $2 million pardon sales. That's what I'm saying. Yeah. I mean, and that is one of those fundamental constitutional powers that the Supreme Court says there's absolute immunity covering it. The pardon power. So, except in the state cases. Yes, that's right. Held accountable. Yeah. I mean, it's tough. That's a tough situation though to be in. When you've got all of your friends getting arrested, because I think too, like how would we keep things going on these cases if he did come into court? I don't know, everyone. I don't know. And we've just got the new information too about Bill Barr regarding, what was it, Egypt? Like, I don't know what's going on. Like, we just got done with the gold bars in Egypt. Like, what? I mean, there's some questions. Yeah, the state cases are state situations, state jurisdictions. So I'm not talking about any of the state cases. This would be any of the federal cases that were involved. Because we've got, if you go through that DC case, we've got unindicted co-conspirators, plus we have a ton of people known to the grand jury that aren't necessarily unindicted co-conspirators, but other people that are involved that could have charges against them later. So all of them could have been involved and could have charges against them later. Mm-hmm. Yeah. And so long as the statute hasn't run, I mean, there's all kinds of criminal cases. Yeah. I don't know what's going on in Egypt. I'm not trying to be offensive about Egypt, but I don't know what's happening with Bill Barr in Egypt. I will say Bill Barr is suspicious. Now, he's suspicious for a lot of reasons, and just because he had a couple of things that seemed to make sense around January 6th does not eliminate the suspicion. The amount of time that he was in office, I think a lot of what he did was very suspicious. Counterproductive. Yeah, I agree. Well, I mean, I don't know what's going on in Egypt. I used to keep up on what was going on in Egypt, but then things took a turn, and I was like, I can't watch. I can't watch anymore. I can't watch. Yes. Yeah, there's a lot. Is a runner to move a middle? I think that's a great description. Middleman. I think that's a great description. Yeah, I mean, what country wouldn't? If money's going to get you where you want to go, and you've got, a country that you're, wanting to take places and influence people, I get it. The only thing is that it used to be that, presidents couldn't be bought, and that's just not really the case apparently. The other thing too was it was rare when we found it was just a once in a while situation when you had Congress people on the take. And now I feel like every week we're finding some kind of elected person on the take, like all over the United States. And I'm just like, come on, are you not getting paid enough, everybody? What's going on here? What's going on? It's really shameful, in my opinion. And I mean that. I think if you've got bribery questions being asked about you that involve grand juries, it's, that's unfortunate. I think that's not good. $10 million in 2017, 5 days after inauguration. So, yeah, and the thing, though, VC, that gets me is that we still have that huge report that came out from the House Oversight Committee regarding all of the millions of dollars that had been paid to Mr. Trump, through various countries. I think they had listed 22 countries, and then there were like a whole bunch more that weren't even in the report. And so I keep thinking, like, yeah, that was a lot, but, is this just another one that was not really fleshed out in that report? Right. $8 million in his hotels and hotel records. Exactly. That's what I'm saying. So this is kind of like, yeah, it's a lot. Why are they paying him? Great question. I don't know. I just don't know. And, yeah, 22 plus countries. Yes. If you ever get a chance to, I don't know. No one's going to read that report. I mean, I'm still trying to work my way through Project 2025, everybody. I tell you what, right after I got out of the Department of Justice, I fell asleep. I'm like, I can't do this anymore. Like the horror, I became numb to the horror and I fell asleep on the last stack of the book. I'm like, I need to go back through here. I'm trying so hard to make it through, but if you can't make it through Project 2025, you're not going to be able to make it through that House Committee report because that is dry. That is desert dry. And there's a lot of receipts. And there's an entire extra PDF that's like 1,000 pages of receipts. And you're flipping through and you're like, what hotel? Who was it again? Like, it's a lot. It's a lot, everybody. I'm still working on it. It's still here on my table looking at me. And I'm looking at it and it's looking at me. Oh, my gosh. They made zip code on purpose. I agree. I think that's very true. Yeah, it's a lot. But yeah, the House report is fascinating because it really does go through and break down by numbers exactly which country and how much money. So very suspicious. And it seemed like it hit the news really like hard and fast, and then it just flamed out. And, meanwhile, I still have the report and I'm like, how people's really, it's just too dry to talk about, I think. It's just too dry. You got to make it more flashy, House Committee. Come on. You got to, add some pizzazz to the numbers, like, I don't know, dress up the receipts or whatever. Yeah, I think there'll be a lot more of that picked up too. Yeah, I agree. We'll have to see how that goes. Again, everybody, the entire House of Representatives in Congress is up for re-election. 33.3% of our Senate is as well. So a lot. The Razzle Dazzle. Oh, I know. Oh my gosh. That's one of my most favorite musicals. I just always have that song in my head. People need Jerry Springer in it. Well, it's so true, Jacob. I keep remembering back, and I encourage others to remember this too. During the New York criminal case against Mr. Trump, right? The hush money case, and everyone is saying, oh, it's election interference. I'm like, I get it, I know, and that's very important. But it was the razzle dazzle. It was the testimony. It was the transcripts. And, I can't even remember the dude's name that's in charge of the National Enquirer. And he's like, people want to have that. And it's the pizzazz in the moment. And all of these people, and we talked about this before, how this base was made out of the people who were supportive of the National Enquirer. So we've got kind of this demographic of people. Not that there's anything wrong with the National Enquirer unless you are, unless it's biblical for you. And then it's maybe an issue. I'm just saying. Peter, thank you. Yeah. If that becomes your your number one, that's, it's kind of a thing. But they do. They want some of that pizzazz. So We can't make it that exciting. I mean, it's a bankruptcy filing. There's not there's not much. There's not much that's too exciting about that. Well, right. And we all like a good something on fire, but just not all the time. And that's, I think, the difference between and the media is just running after one thing to the next thing. Like this woman today, this is my moment, everybody. This woman today I went to a grocery store and she was in front of me and she just was buying a loaf of bread and she got change back. And I'm just standing there waiting for my turn. I'm just waiting patiently. And she is slowly putting all of her change back into her pocketbook and picking up her loaf of bread and slowly moving to the end of the, belt and so on. And then right before the cashier started checking my things out, this woman's like, oh my gosh, these are the most crisp $1 bills I've ever seen. And she starts showing off this $1 bill. And I'm like, we don't do that anymore. We don't take our time to put our money in our pocketbook. We don't get excited about crisp $1 bills. Like, we're all just moving too fast here. Too fast, everybody. It's too fast and too sensationalized. Everyone's looking for the $20 bill, not the $1 bill. So that's my moment of saying, what's cash exactly? That was the other thing. I was like, what is that you're holding in your hand? That's some kind of exchange for something else? What is that? She did. She paid with money. I know, everybody. I know. But that's the moment, though. Like, everything is so fast now. Like, you just get your stuff, ring it up, then move on. And meanwhile, this woman is like, la, 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 la. Here's my loaf of bread, and here's my cash, and I'm so excited about my $1 bills. And like, why can't we enjoy a moment like that? Yes, money's dirty. I get it. Money's dirty. I'm with you. After COVID, I have to admit, I struggle with money. I do. I'm with you on that. But again, as long as she was at the end of the aisle, well, she was, but we all had to pause because she was kind of taking up the space. You know what I mean? Like, she was in the way. And before I was like, okay, this isn't a Hulk moment. Let's just pause for a moment, see what this lady's doing. And then it was like, oh, look at that. Isn't that cute? Okay. Sorry, Jacob. I got distracted by my $1 bill story. You're like, back to business. Oh, my goodness. Oh, my gosh. All right. Yes, let's talk about that for a minute. Oh, my goodness gracious. All right. So, right, we talked about this a little bit before. So Biden had this proposal. He wanted to, all right, everybody, help me out. He had 3 things he wanted to do. So let's see if we can remember Biden's proposals. We had 3 things. Term limits was one, right? Term limits. And he wanted to do an amendment. He wanted the No King Amendment, essentially, is what's happening. And then what was the third? 18-year term limits, right? What was the third one? Oh, and ethics. He wanted to have something to make ethics enforceable. So we had 3 big things. So enforceable ethics. Right. So those were his proposals. Yeah, that's right. That's right, everybody. That's right. Yeah, which, it's difficult. It's difficult to figure out a way to get those ethics enforced. Meanwhile, we're all like, dude, can you get the court bigger? I think that's one of the biggest questions is expanding the court. And we talked about that before because, right, we've got 12 circuits. We've got 9 Supreme Court justices. So we're like, what's happening here? And then everyone's like, make it an odd number. So we're like, okay, 13. So we came up with this magic number 13. And I'm all for that. I think that needs to happen. We need to make that happen, everybody. 13 justices. That needs to happen. Plus DC, right, Trish? Right. Valid. Exactly. We can never forget about DC. Right. Investigation going anywhere the AOC wanted. I'm not sure which one you're talking about. She's She's got a lot of things going on. She's hardcore. I love that for anyone who is passionate about those kinds of things. 27 cents. You paid with those round silver things. Oh, that's so funny. Oh my gosh. What's a round silver thing? Oh, that's so funny. I like DC as the 13th. Yeah. So this was for Supreme Court, right? So this is what we're talking about. So this was Biden's proposal here. So he had said, let's do 18-year term limit. Let's do an amendment so that there's no, genie power is what I refer to it as, no unlimited power as president, and then some way to enforce the ethics code. So that's what Biden was talking about. But it seems time and time again, anytime I bring up the Supreme Court and changes here, when I'm talking on these lives, the number one and number two have to be involving expanding the court and making it larger. That seems to be like one of the biggest things that people are really wanting to see happen is a bigger court. The second one, without a doubt, has to be age. And that's, I hesitate to even say that because that's going to get us into an argument. We're all going to be like, wait. But it seems like expanding the court and how old the people are tend to be the two number ones here. Well, the thing is, if we wanted to expand the court, Congress has to do that, all right? So Congress can expand the court through a judicial act. So that's how the court has expanded it before and shrunk it and expanded it again. So we would have to have a congressional act passed and they could expand it. Too many cooks. Well, the reason why we had set it at 9 before, again, this was like what, 18, oh my gosh, what was it, 1893? That sounds too late. 1860. It was after the Civil War. I apologize. I can't remember the year. I think it was 1893, maybe. The last judicial act, I'm going to guess it at 1893, but I hold the right to be incorrect here. But that was our last judicial act, and it's set at 9 because of how many circuits we had. So that's why we're crunching these numbers here. That's going to bug me all night. Was it 1893? Was that right? Oh, maybe it was 1868. Oh my gosh, everybody. All the numbers, all the years blend together. It was right after the war. And 1893 was like 20 years after the war. So I don't know. It doesn't sound right. It doesn't sound right at all. I don't know. 18 something. It's been too long. 1869. Oh my gosh. Mary for the win. 1869. Oh my gosh. I feel like I can exhale. All right. So that was the last time we had the number of justices changed, everybody. I think it may be time. It may be time, for goodness sake. Yeah, 1869. Thank you, everybody. I appreciate that. I thought there was a 9 in there somewhere, but who knows anymore? All of the numbers get all mixed up. Right. Right. Yes, thank you, Google. Whatever. However we got there. I appreciate it. I'm thankful for that. But yeah, so the expansion. But for whomever was asking about what Biden's plans were, what his proposal was, he had 3 pieces he was proposing. But there's a lot more that I think people are really interested in. One for every circuit in DC. Yeah, I think that's a good idea myself. I think that would be helpful. We talked about all kinds of things too. If we were going to restructure Article 3, do we want more than one Supreme Court? What if we had 2 Supreme Courts, one for civil, one for criminal? What if we had some kind of a rotating process of people every few years that would sit on an ethics board to watch over the Supreme Court? I mean, there's all kinds of ideas out there. It's just a matter of finding one that's going to work. Right. Well, the age thing's tough. Everybody. It's tough. We got to be careful here because I'm telling you, in our field, in the legal field, we age different. Age is a little different in the legal field because we practice. The longer we practice, the more we know, the better we get. So, that's like, I think we talked about once, like, well, what about pilots? They age out. I'm like, that's a true story. But for us in the legal field, like, age is an advantage. But then there's, the law of diminishing returns. So how do we assess the age versus the competence issue? Because, you can hit 70 and not understand how to make a peanut butter and jelly sandwich, or you can hit 70 and be able to write us a brand new constitution. I mean, there's just no way to know. It depends on each person, depends on each individual person rather than the age itself. Yeah, I mean, it's a case by case, person by person. Being president ages you. Oh, it does. It really does. It really does. No older than 54 at the time of point. I don't know. I mean, legally, and as far as in the legal field, 54 is like you're a babe in the woods. You're barely able to walk at 54 as a lawyer. You're still seen as a new lawyer. You know what I'm saying? We just have kind of a different view in the field the longer that you've been in it. Student loans go down, education goes up. Yeah, that would be nice. Workload is going to quadruple. Oh my gosh. Minimum, I think it'll be more than that. I think after Chevron, we'll have 10 times as many cases. At least I hope. I hope people will bring cases instead of giving up on it. That's my hope. My hope is that they don't say, well, it's too much work because we got to take every single thing to court and forget about it. I hope that they pursue it. Meanwhile, the judges, which we have a judge shortage in the entire country, especially through administrative law, and they don't get paid much at all. Hashtag Thomas. They don't get paid very much. They don't have very good benefits. And meanwhile, their workload's going to increase enormously. So there's a lot going on. Your body doesn't feel like a babe in the woods. Could be, but what about your brain? And we're all about the brain. The brain does our business here. We're all about the brain. And so for us, the more you learn, you keep working at it. Yeah, I mean, I can wheel you into the courtroom. It doesn't matter. But if your brain's working, I mean, that's all we need. We just need your brain. That's it. And sometimes that's happened. Sometimes I'm like, please just get me into the courtroom. Like, I've had a broken leg before. I've had all kinds of things going on. And I'm like, it doesn't matter. Just put me in the chair and put me into the courtroom. We'll get her done. Oh my gosh. Yeah, it just, it's a different field, everybody. It really is. It really is, because the more every single day you gain the knowledge, and the more knowledge that you gain, the better you get. So, I mean, it's just a little bit different situation. Yeah, so those are the big questions. But, taking it back again, Biden has some ideas here that he wants to do. And, if he wants to do it, he wants to do it. And I forgot who it was that was proposing the No King Amendment. There was somebody that was like the No King Amendment, where there's no absolute immunity. For me, I would call it the Genie Amendment. So, unlimited power. But the No King Amendment's been proposed. We'll see how that goes. Was it? Schumer. Schumer. Okay. Thank you very much. I knew it was somebody. But yeah, someone's been doing that. We've got that that's been proposed. So that's one piece of it. But the other parts of it, we'll see how that goes. I really have no idea what kind of a time frame. Well, mental competency, that's the question. See, for me, that's more of an issue than age. I think competency and age don't necessarily go together, although they can, but not necessarily have to. So, competency, I think, is a good question. It's a very good question. I'm not sure how we could measure that in a way that wouldn't be an invasion of privacy, and that would be equal, that would be fair to everybody. So I'm just not sure. But something, because you really need the competency element here. You really do. You really need that on the court. We need to have the judges competent here. That would be great. Now, I also heard everyone, I don't remember even where I read it, that Alito is talking about stepping down. I'm hearing that as well. Average people at state level, I agree completely. VC, I agree. Dementia tests are not a good measure. Well, that's what I'm thinking too, Chris. That's what I'm wondering as well. Like, what kind of a test would be appropriate? I'm just not sure. The police, really? Do the police require that? I don't know. I've trained police officers. I don't remember any of those kinds of tests. Mental health. Yes, I think that's a better way of putting it, right? We have physical health and we have mental health. And, as long as the mental health is in the right place, you're good to go. Yeah, yeah. Repass the bar. Oh my gosh. Oh, that's harsh. That's not worth it. That's not worth it for anybody. If you had to repass the bar to be a Supreme Court justice, then that's not the person that you want in the court. No, 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 no. No, no. Only if Trump wins. All right, well, whatever. I don't know. It seems like he's still got some trouble that he's got to do. So, state law and agency policy. Yeah, yeah, I know. It's complicated, everybody. There's no easy questions. It's multi-layered, and I'm not sure how we're going to get to a good answer for everybody at some point. We've got to figure something out. But yeah, so police have to take a mental health test. Well, mental health, right, right. But again, that the mental health kinds of tests are, what kind of tests? I think those are different for different places. I'm not sure what that would necessarily look like. That would be across the board for everybody. How do we get it passed? Well, you gotta talk to your representative and see what they think, and then based off of what they think, you either vote to reelect them or not. I think that's a good piece. That's a good starting place, just to say, hey, what do you think about that? And then they're like, well, I'm against it. And you're like, okay, well, I'm not going to vote for you then. I'm going to go. I take my Kellogg cereal and my Nestle hot chocolate, and I'm going to get out of here. I joke, everybody. I joke. It's too soon. Too soon. Universal basic dental care. Oh, that would be, oh my gosh, dental. Oh my gosh. Oh my goodness gracious. Dare to dream on that. Well, we've got to do something. I'm not sure exactly what it's going to be, but we need to have something in place. Well, absolutely, VC. That's where it starts. The foundation is your health. If you can't, if you don't have the ability to take care of your health or get the health help that you need, then everything else goes. So that's absolutely so true. So very, very true. I agree. 150%. 150% for sure. So, require interpretation and analysis of a person. Right. And there's a lot of nuances. There's a lot of nuances involved in mental health. It's complicated. The brain's very complicated. Which reminds me, everybody, I was on my live earlier today. People were asking me if I could bring my significant other, if he would make a guest appearance. And I tell you what, I'm working on it. I'm working on it. I was asking him, I'm like, hey, can you just like stop by on one of my lives and say hi? And he's like, well, for what? For why would I do that? So I'm thinking, everybody, we've got to figure out a science way. Like, can you explain some kind of science maybe to the people? And I think if we can get them out here, if there's a science question, a legal science question, I think I might be able to do it. We'll have to do a mashup. So I'm thinking really, really hard, everyone. So if anyone's got suggestions or science law questions, just let me know. And I'll see if I can be like, everybody really, really wants to know about this, but not something just like, explain the spleen. Because I have to hear how a spleen works one more time. But if it's something else, we might be able to. Oh, Suze, I know. I asked him about that, and he's like, he's like, I'm sorry, do you not know me? That's what he said. So I'm working on it. Oh my goodness. We'll see. Yeah, I think the Chevron stuff will do it. Maybe on YouTube. But I think if I can find the proper carrot, I'll be able to get him. I'll be able to get him in. Really, that's an interesting question. Let me ask him that. Yeah, pretty much any kind of, again, his area is genetics, anatomy, and physiology, and so if it has anything to do with that, he's all about that. But I got to find a hook because he hates legal stuff. He hates all of this stuff. Oh my goodness. But anyway, I'll see what I can do. And try to bring him in sometime. I think if you think I'm funny, He's 10 times funnier than I am. So I think it'd be fun to have him on, but we'll see. I'll keep working on it for sure. Genetics lecture. Well, we'll see. We'll see. Oh, anyway, with that, everyone, I will go ahead and sign off for tonight. I think I've just chatted your ear off long enough. Really? Yes? Oh, good luck, Denise. Good luck. So I will go ahead and sign off for tonight. Now, I am trying to come back for sure on Wednesdays, but we've got a lot of things going on right now. So if something comes up and an interesting thing gets filed, I will come on before Wednesday. But if not, I will definitely be back on Wednesday, everybody. And then traditionally, I will be on my YouTube channel or my Tube of You on Saturdays. That's when I stream over there. So thanks for coming and hanging out with me, everyone, for my Sub Chat Sunday. Thank you to all my subscribers. I'm so grateful for your help and assistance. And everyone else who's been hanging out, always wonderful to see you all. So have a wonderful night. Thank you, everyone, for coming by, and I will see you all very soon.